Assalamualaikum warahmatullahi wabarakatuh. My name is Ulfa Nabila and my metric number is 1232065. Today, I'll be presenting the case of Majlis Agama Islam Wilayah Persekutuan and Victoria Jaislin Martin and another appeal. This case occurred on 24 of March 2016 and has proceeded through three courts, which is the High Court, the Court of Appeal and the Federal Court. There are no precedents cited in this case because this case is a landmark ruling that addresses the issue of admitting non-Muslim as peguam syar'i in Wilayah Persekutuan. Let's move on to the fact of the case. So, who is the respondent Victoria Jaislin Martin? She is an advocate and the solicitor of the High Court of Malaya and a holder of a Diploma in Sharia Law and Practice (DSLP) conferred by International Islamic University Malaysia. So, Mrs. Martin, who was of the Christian faith, has applied to the Majlis Agama Islam Wilayah Persekutuan for the admission as a Syar'i lawyer. However, she was informed that her application could not be processed on the ground that she was not a Muslim. This is because according to Rule 10 of the Peguam Syar'i Rule 1993, which we'll refer to as the rules, Syar'i lawyer must be a Muslim. This is why the respondent applied to the High Court for a judicial review as she argued that Rule 10 of the rules was ultra-vires with Section 59, Subsection 1 of the Islamic Law Act 1993, which we'll refer to as the Act. She also claimed that Rule 10 of the rule was in contravention with Article 8, Clause 1 and Clause 2. However, the High Court ruled against her. Aggrieved by the High Court decision, the respondent appealed to the Court of Appeal and the court allowed her appeal. However, the Majlis brought the case to the Federal Court, which then issued judgment in their favor. Next, after hearing the fact of the case, what is the objective of this case? First, it is to determine whether the rejection of a non-Muslim's application to practice as Sharia lawyer infringe on constitutional right, particularly in relation to equality. Second, to ascertain the boundaries of religious freedom when applied to a specific legal system based on religious doctrine. And last but not least, the objective of this case is to establish the precedent for future Sharia lawyer qualification. What is the legal issues in this case? First, whether non-Muslims can be admitted as peguam syar'i. Next, whether Rule 10 of the Peguam Syar'i Rules 1993 was ultra-vires with Section 59, Subsection 1 of the Islamic Law Federal Territories Act 1993. Then, whether Rule 10 of the rules was in contravention of Article 8, Clause 1 and Article 8, Clause 2. The law applicable in this case is Rule 10 of Peguam Syar'i Rule 1993. This rule stated that only Muslim is permitted to be a Syar'i lawyer. In the Federal Constitution, Article 8, Clause 1 and Clause 2 is applicable as the respondent believed she was not treated equally as she has been discriminated on the ground of religion. Next, Section 59, Subsection 1 and Section 59, Subsection 2 of the Administration of Islamic Law Federal Territories Act 1993. Section 59, Subsection 1 only stated that any person can be a Syar'i lawyer as long as he or she have sufficient knowledge of Islamic law, which Mrs. Martin believed she had fulfilled the requirement as she is a holder of the SLP. Then, Section 59, Subsection 2 stated that Majlis with the approval of YDPA can make rules including the rules of qualification of peguam syar'i. Let's take a look at the judgment of the court. The High Court dismissed the respondent application for judicial review on the grounds that the Majlis was empowered under Section 59, Subsection 2 of the Act to make the rules relating to the qualification of admission of persons as Syar'i lawyer, including the power to impose the condition that a Syar'i lawyer must be a Muslim. In the Court of Appeal, however, the respondent won the case as it was declared that Rule 10 of the rule was ultra-vires with the Act. However, the Federal Court upheld the decision of High Court as it was ruled that Rule 10 of the rule is in line with Section 59, Subsection 2. It was further held that one of the most important criteria which made an upright and vicious peguam syar'i was for the lawyer to have akidah. Moreover, the law did not violate Article 8, Clause 1 and Clause 2 of the Constitution as it is deemed necessary for the purpose of achieving the objective of the Act, thus make it a good law. Moving on to the legal analysis and discussion, the Federal Court decision upholding the High Court decision is deemed a reasonable interpretation of the balance between religious freedom and the administration of Sharia law. As I stated before, the argument made by the respondent, Mrs. Martin, which she claimed that she had been discriminated on the grounds of religion, is not valid, as the requirement that Peguam Syar'i need to be a Muslim is necessary to uphold the divine law. This proved that Rule 10 of the rule was consistent with Section 59 subsection 1, as this section depends on section 59 subsection 2, which give Majlis the power to make rules for the admission of Peguam Syar'i in Wilayah Persekutuan, including the requirement that the applicant must be a Muslim. It is very reasonable of the judge to held that Aqidah is one of the most important criteria to be a Peguam Syar'i, because how would a non-believer Peguam Syar'i represent clients in court, given the fact that she does not even believe in Allah and His divine law? Would she be able to defend her client with Al-Quran and Hadith as her sources? On the whole, the Federal Court's decision in this case affirmed that the requirement for Syar'i lawyer to be a Muslim is constitutionally valid. This ruling highlighted the unique nature of Islamic law and the importance of having practitioners who are adherents to the faith to ensure proper understanding and application of Sharia principles. It reinforced the jurisdiction boundaries between civil and Sharia courts in matters related to the practice of Islamic law.